Today in court, something disturbing happened. Mental health was raised, and instead of protection, it was brushed aside. When a defense lawyer raises psychological pressure and it's dismissed, the question becomes unavoidable. Is this still a fair trial? This is the moment everything changed. Watch this and listen very carefully.
Yes, Mr. Baloyi, any view?
Well, my lord, we would have thought that what we place on record earlier on should place everybody at ease, that whilst there's an investigation going on, that the necessary security measures have been put in place for this trial to continue. However, my lord, we really cannot force my colleagues to continue with the trial. I think it's an individual choice, but if anyone is concerned about their security, we can assure them that the security measures have been put in place for this in order for this trial to continue.
Is it with the court, my lord? May I request the permission to go see Mr. Mngobe?
Yeah,
He's been raising his case. Thank you.
May I also request an indulgence? Thank you, my lord, for the court's indulgence. Thank you.
Thanks. Yeah, there is a request that this matter should be postponed pending an investigation by the police, whose job is to investigate. This court can't know when the police are going to finish their investigations. And the process and the progress of this court cannot be hampered by a police investigation, which may take 20 years. That's ridiculous. I don't know, 2 days, 5 years. Fact of the matter is, I've spoken to the police, and they have assured me that they have arranged adequate security for everybody who is involved in this case. Consequently, that application cannot succeed. Okay.
Is this my lord?
Yeah.
I'm mentally not fit.
Hello?
I am mentally not fit subsequent to those allegations that were made against me. So if the court is forcing me to proceed despite the fact
What do you mean I'm forcing you?
No,
What do you mean I'm forcing you?
my lord, I am being expected to proceed with this trial despite these allegations that have been raised against me. I've told the court I'm mentally affected.
You okay?
And psychologically too. I don't know. Thank you, my lord.
Now this case continues. If you want to exercise your discretion or choice to do whatever you want, you are at liberty to do that. But the order of this court is that we must continue. If you are telling me something like that you want to go and consult a psychologist or a doctor, fine. But you can't say open-handedly that you can't continue the case.
Thank you, my lord. I think I will have to go consult today.
Want to do it when?
I don't know, my lord. I'll have to make arrangements.
Yeah, when? I want to know.
I cannot start to make arrangements when I'm here at court, my lord.
Okay, we can adjourn until tomorrow. Any other person who wants to consult a doctor, a psychologist, a herbalist?
Good spirit.
Hello?
I'm in good spirit.
You?
I'm in good spirit.
I can't hear you.
I'm in good spirit. I don't have a problem.
Yes,
Yeah.
I can see you're a man.
There you have it. Let us now talk about Judge Ratha, judicial demeanor, and mental wellness in a murder trial. The conduct attributed to Judge Ratha raises serious concerns about judicial sensitivity, impartiality, and the constitutional duty to safeguard fairness in a high-stakes murder trial. Courts are not only arbiters of law, they are guardians of dignity, equality, and procedural justice, especially where power imbalances and psychological pressure are evident. Allow me to deliver 5 crucial points. Number 1, judicial attitude and the power dynamic. When a presiding officer appears unmoved by allegations of harassment toward the defense, it risks normalizing intimidation within the courtroom. The reported dismissal of concerns raised by Advocate Manisi, particularly where mental well-being was explicitly mentioned, creates an impression of indifference to a material factor that can affect counsel's effectiveness, independence, and client representation. In a murder case where consequences are irreversible, such perceptions are corrosive. Number 2, trivializing mental wellness. The alleged exchange questioning Zitulele about mental health, followed by a remark implying that being a man diminishes the relevance of psychological harm, reflects a troubling stereotype. Mental wellness is not a question of gender or toughness. It is a professional and human concern. Courts should be acutely aware that sustained accusations, threats, explicit or implicit, and public insinuations can impair concentration, judgment, and ethical independence, factors central to a fair trial. Number 3, chilling effect on defense advocacy. When defense counsel's well-being is downplayed, it sends a message that robust advocacy may be punished or belittled. This can chill legitimate objections and discourage the defense from raising issues essential to testing the state's case. The right to a fair trial is undermined when one side fears that raising concerns, especially about harassment, will be met with ridicule or dismissal. Number 4, standards of judicial conduct. Judicial officers are expected to act with restraint, empathy, and neutrality. A courtroom culture that appears dismissive of mental health concerns risks breaching these standards. Even the perception of bias or insensitivity can erode public confidence in the judiciary, particularly in emotionally charged murder proceedings where scrutiny is intense. Number 5, why mental wellness matters in murder trials. Cognitive performance. Trauma and stress impair memory, attention, and decision-making. Ethical independence. Harassment can coerce or intimidate, compromising counsel's duty to act fearlessly. Equality of arms. If one side's well-being is disregarded, parity between prosecution and defense is lost. Public confidence. Justice must not only be done, but be seen to be done, especially when lives and liberty are at stake. I want you to think carefully about this, not emotionally, but constitutionally. If mental health concerns raised in open court can be brushed aside, what message does that send to every defense lawyer watching? Can a trial truly be fair when psychological pressure on one side is treated as irrelevant rather than protected against? Where is the line between judicial authority and judicial insensitivity? And who guards that line? Should gender or toughness ever be used to diminish mental wellness concerns in a courtroom? If defense advocacy is chilled through dismissal or ridicule, who ultimately suffers? The lawyer, the accused, or the justice system itself? If accurately reported, the behavior attributed to Judge Rata risks minimizing legitimate concerns about defense harassment and mental wellness, thereby threatening the integrity of the proceedings. Courts must actively protect the psychological safety of all participants, particularly defense counsel in a murder trial, to ensure fearless advocacy, equality of arms, and public trust. Mental wellness is not a peripheral issue, it is integral to justice. To everyone who took the time to watch, reflect, and engage, thank you. This channel exists because you care about truth, fairness, and accountability. Your comments, your support, and even your disagreements matter here. If you find value in this kind of independent commentary, please consider subscribing, joining the channel, or supporting via Super Thanks. Your support helps keep these conversations honest, balanced, and accessible to all. Thank you for standing for justice and for standing with this community. I'm Skybridge. Until next time, goodbye.